Thanks so much for that generous introduction and for inviting me to speak about the use of the selection and confirmation process to mold the contemporary Supreme Court. The process of naming justices has become more partisan, it's said, since the Bork nomination. The court, both more and less diverse. On the one hand, we see 3 women and 6 men, 3 Jews, 5 Catholics, and just 1 Protestant who was raised as a Catholic. On the other, until Justice Scalia's death, there were 4 New Yorkers, and all the justices attended Harvard or Yale Law School, as they do today. All but Justice Kagan were federal judges before appointment, and none were presidential friends. In the past, geographical distribution proved more important, and justices had more diverse training. Some were politicians, academics, lawyers, and presidential intimates before becoming justices. How did the court come to be drawn from such a narrow bandwidth? The answer, I'll suggest, lies in the 60s, a decade that includes the 1970s, early 1970s. At that time, LBJ and Nixon worked harder than any of their predecessors since FDR at finding ideologically compatible justices and at using the court to bolster their presidencies. Now, admittedly, that's not saying much. Truman used court vacancies to reward friends, and Eisenhower broke with cronyism by turning to judges, with the big exception of Earl Warren. JFK, who viewed the court as unimportant, gave friends nominations, though he complained, "I don't know why they all want to go into retirement up there." To LBJ and Nixon, the Warren court embodied legal liberalism, the trust in enlisting court and constitution on behalf of the disadvantaged. The 6 years between 1965 and 1971 witnessed 2 successful nominations by LBJ and 2 failed ones, 4 successful nominations by Nixon and 2 failed ones, the forced resignation of 1 legal liberal, and the attempted impeachment of another. Even by 19th century standards, when the Senate rejected 1 in 4 court nominees, the conflict during this period was remarkable. I'll sketch the struggles and then turn to what I think are their consequences. Our story starts in 1965, when LBJ decided that he needed a spy to apprise him of Warren Court activities. Concerned that 2 Jewish justices would be overdoing it, Johnson lured Justice Goldberg to the United Nations. LBJ then appointed his loyal advisor, Washington super lawyer Abe Fortis, to the Jewish seat to preserve the court's ideological momentum. But while LBJ believed the Warren Court was the greatest court ever, he worried. The justices should tell inner-city rebels to stop rioting and turning over cars, Johnson directed Justice Fortis in 1966. Earlier, civil rights and the war on poverty had justified changes in criminal procedure. They made many equate the Harlem cop who abused poor people of color with the racist Southern sheriff who brutalized civil rights demonstrators. But by 1966, some were racializing crime by trumpeting white distress about law and order. As LBJ saw it, inner city unrest and street crime jeopardized his and the Warren Court's interracial liberalism. He told Fortis that white fears about crime hurt him in the polls more than anything else, including Vietnam. Now, why would LBJ have thought that the justices should care about his poll ratings? Because he saw the Warren Court as part and parcel of his great society. He wanted Fortis at the court to keep an eye on the store and to advise him on affairs of state. In 1967, Johnson sought to strengthen the Warren Court majority and get rid of Attorney General Nicholas Katzenbach, whom he considered too close to Robert Kennedy. First, the president moved Katzenbach to the State Department. Then he let Justice Tom Clark know that LBJ wanted to make Tom's son Ramsey Attorney General, but the nepotism concerns would prevent that unless Ramsey's daddy quit. Well, Ramsey Clark was already Deputy Attorney General, and senators in both parties were untroubled by the idea of one Clark at the court and another as Attorney General. LBJ was replacing Katzenbach with a loyalist and getting a second court vacancy in the process. Once he had it, Johnson created the Black Seat for the venerable civil rights lawyer, judge, and Solicitor General Thurgood Marshall. He acted partly from political calculation. With inner cities exploding, LBJ hoped the appointment might, as he said, kind of rock the Negroes and put them in a position where they wouldn't be mean to me. He fretted that Marshall's addition would mean the liberal Warren Court wouldn't send a man to the penitentiary for raping a woman, even if you had a photograph of him doing it. Yet LBJ remained a fan of legal liberalism, and Fortis had told him that the Warren, Brennan, Douglas, and Fortis bloc could no longer count on Hugo Black, and that Marshall would give them a fifth vote. But in a new development, a few senators tried to keep Marshall off the court. Except in the case of John Parker, the 20th century Senate had been a lapdog on court nominations. Once the Judiciary Committee began holding public hearings in 1938, nominees appeared intermittently. They only appeared routinely after Brown versus Board of Education, and their evasiveness on the grounds that questions raised issues that might come before the court is no recent phenomenon. Senators still typically confirm them overwhelmingly or by voice vote. By the end of the 1950s, some hearings included grousing about the Warren Court, but it was just hazing. Senators assumed that advise and consent meant advise and approve. Even the grumbling dwindled between 1962 and 1965 as senators hailed JFK's White and Goldberg nominations and in 1965 applauded LBJ's choice of Fortis. But in 1967, when Thurgood Marshall came before the Judiciary Committee, the era of good feelings for Supreme Court confirmations came to an end, and a few Southern senators transformed the Warren Court into a boogeyman. Southern segregationists realized that they looked like history's losers in 1967. That's why they did not allude to Brown versus Board of Education when they confronted its chief architect or overtly play the race card. Some Southerners who understood the long game, though, realized that crime could take them where white supremacy could not. For 5 days, they savaged the Warren Court's criminal procedure decisions and Marshall for refusing to discuss them. The hearings became the first instance in modern times when senators justified their close scrutiny of the nominee by predicting that the nomination of Marshall and his replacement of Tom Clark would change the balance of power on the court. And while committee members had quizzed Stewart and Goldberg about whether the Constitution and its amendments still meant what they did at the time of ratification, now calls for adherence to the Constitution's original intention became common among Warren Court foes. Judicial activism and judicial activists two phrases around since the 1940s and insignificant at prior confirmation hearings emerged as epithets for the Warren Court too. For the present, Southerners was a lonely task aimed at reassuring hometown voters. Marshall's nomination was largely acclaimed and he was overwhelmingly confirmed. But despite Marshall's mainstream approval, his brutal interrogation revealed that the Warren Court had become a lightning rod for a minority that complained it coddled criminals. White supremacy had morphed into law and order, though the transformation preserved the underlying racism. The Warren Court's opponents maintained the offensive in June of 1968 when Warren announced his retirement as LBJ readied to leave the presidency. Both Johnson and Warren feared the victory of Republican candidate Richard Nixon, who was making law and order and the court campaign issues. So LBJ nominated Fortis as Chief Justice and another liberal friend, Judge Homer Thornberry, to replace him. Southern Democrats assailed the court's liberal judicial activism, especially on crime. Their Republican allies argued that the lame duck LBJ should save the appointment for the next president, that Fortis and Thornberry were his cronies, and that Justice Fortis had not respected separation of powers when he advised President Johnson. None of it originally stuck. Fortis faithfully became the first Chief Justice nominee to appear before the Senate Judiciary Committee, where he lied about the depth of his involvement in the LBJ White House and defended the Warren Court. As the battle disappeared into the mists of time, some remembered the attempt to make Fortis the scapegoat for the sins of the Warren Court as an effective strategy. But it did not seem like an effective strategy in 1968. Not everyone who attacked Fortis disliked the Warren Court. Fortis's leading Senate Republican opponent said he'd take Arthur Goldberg as Chief Justice, and Goldberg considered Fortis his ideological clone. Many revered the Warren Court and found those who bullied Fortis as simple-minded about crime as Joe McCarthy was about communism. Consider what happened when Strom Thurmond berated Fortis about a Warren Court criminal procedure decision handed down years before Fortis joined the court that released an African American from death row who then committed more crimes. Fortis won points in this exchange for his restraint. Senator Thurmond's staff mourned that Thurmond strengthened the nominee by transforming him into a martyr. The momentum stayed with Fortis. Judiciary Committee members supported him by a 2-to-1 margin, as did the public, ABA, and the Senate. But Fortis's opponents finally got the game changer they needed when the Citizens for Decent Literature belatedly zeroed in on Fortis's and the Warren Court's obscenity decisions and urged senators to watch the constitutionally protected dirty movies. So we have the much remarked on spectacle in 1968 of senators lining up for porn, which the Senate Judiciary Committee chairman predicted would sink Fortis. Then there was the late-breaking revelation of Fortis's honorarium for teaching a summer course, which was not just huge, $15,000, about $100,000 today, but was raised by Fortis's former partner from Fortis's former clients. Now, Fortis's opponents could muster the votes to filibuster his nomination. Fortis, of course, stayed on the court as Associate Justice. Warren remained as Chief Justice for 68 to 69. The Nixon administration then launched a smear campaign against Fortis, who had given it plenty of grist for its mill by becoming involved with a charitable foundation headed by a former client who was an indicted stock manipulator. In pressing him to quit, the administration publicized an FBI file saying that Fortis had sex with an underage boy and threatened to indict two of his former partners, one of whom was his wife. That Fortis would cast a long shadow over this court became clear a week after he became the only justice ever to resign in disgrace. Nixon nominated as Chief Justice D.C. Circuit Court Judge Warren Burger, a critic of Warren Court criminal procedure decisions. The president's advisors had warned him off anyone who could be seen as Nixon's Fortis. Nixon told reporters that the Fortis hubbub had shown that he must avoid a political intimate, in Washington vernacular, a crony. He also promised to replace Fortis with a judge. Appellate and district court experience give the individual an edge, the president said. Now, Nixon now embarked on his Southern strategy aimed at winning the South for Republicans, and he nominated Fourth Circuit Judge Clement Haynesworth of South Carolina for the Fortis vacancy. Liberals argued that Haynesworth was anti-labor, anti-civil rights, and guilty of financial conflicts of interest that made Fortis look like an altar boy. No allegations so irritated the Nixon administration or proved so effective as that last, conflict of interest. And of course, Haynesworth was defeated. The venom that the Fortis affair caused has now been expended, Haynesworth then told Attorney General John Mitchell after his defeat. The next nominee, Haynesworth predicted, would be a shoo-in, and no group in the Senate will be anxious again soon to turn a reasonable appointment into a matter of great controversy. Wishful thinking, since the next nominee proved neither reasonable nor a shoo-in. Advisors urged Nixon to choose a Southerner with no paper trail, but he stayed fixated on judges. If Haynesworth's selection was bad for the moment, that of Fifth Circuit Judge G. Harold Carswell was just bad. A network of liberal law students, lawyers, professors, labor leaders, and civil rights leaders that included the AFL-CIO, the Leadership Committee on Civil Rights, and Chicago Daily News reporter Bill Eaton had trumpeted news about Haynesworth's alleged conflicts of interest. Now that network again mobilized senators when its members revealed what the FBI had failed to uncover, that Carswell had championed white supremacy and that he had dodged public integration of a golf course by reconstituting it as a private club. But liberals knew, as one of them said, that they couldn't win by making it a strictly civil rights fight. The lesson of the Fortis and Haynesworth battles was that opponents needed a cover issue to show that they respected the law-politics distinction. So while Carswell presented himself to the Judiciary Committee as the antidote to the Warren Court, his antagonists charged that he was a racist and a mediocre judge whose opinions were repeatedly reversed. The incompetence issue became for Carswell what ethics was for Haynesworth. Memories of the Warren Court suffused the Carswell fight. Assistant Attorney General William Rehnquist complained that Carswell's opponents sought the restoration of the Warren Court's liberal majority. Before Senator Hruska famously said that mediocrities deserved representation on the court too, another senator had said that the C student who couldn't think straight was preferable to the A student like Fortis with the kind of thinking that winds up getting us a 100% increase in crime. When the democratically controlled Senate blocked the Carswell nomination, Nixon urged Congress to impeach Justice Douglas, but that went nowhere. He also charged senators with vicious assaults on Hainsworth and Carswell's intelligence and character because of their strict construction of the Constitution and their misfortune of Southern birth. He used the defeats of the Carswell and Hainsworth nominations to exhort Southerners to vote Republican in the 1970 midterm elections. In the meantime, Nixon broke with the tradition of geographical representation in decline since the Civil War. Though Berger lived in Virginia, he was considered a Minnesotan, and Nixon's next nominee was Berger's crony, Judge Harry Blackmun. Once you have two consecutive Minnesota twins from St. Paul, it's not that big a step to a court with justices from every borough but Staten Island. The other tradition that Nixon hoped to break, as his wife and many women urged, was that of an all-male court. He got his chance when Justices Black and Harlan retired in 1971. Political calculation moved Nixon. He thought women erratic and emotional and didn't think they deserved education or the vote. But a woman justice could help him win re-election. No one would vote against him because he named a woman, he reasoned, but some might support him because he did, and the Republicans had to pick up every percentage point they could. The woman must be conservative, which Nixon defined as anti-busing to achieve racial balance in the schools, and pro-law and order. That created a problem for Nixon, since the most qualified women were people like Judge Shirley Huffstedler and others that Nixon considered left-wing bags. But the Justice Department found California Judge Mildred Lilly, whom reporters typically described as statuesque and a great cook. Mitchell assured Nixon that Lilly was no frigid bitch and was also conservative on crime. Moreover, Lilly's husband was named Alfredo Falcone. Good news when Italian Americans wanted representation on the court. So was Lilly's religion. Tell her if she isn't a Catholic to go get confirmed, the president kidded. But she was a Catholic and an observant one to boot. When he wasn't ribbing Attorney General John Mitchell about their shared pride in naming the first woman justice, Nixon radiated delight with the twofer of a woman conservative. They could reject a Southerner, but they had to vote for an African American or a woman who can read and write, he said. He would create the woman's seat and pair Mildred Lilly with Little Rock bond lawyer Herschel Friday, whom the White House would market as the Arkansas Harlan. Nixon now insisted that he had never meant that judges made superior justices. Nixon stayed with Friday even after his aides told him that the Arkansan knew nothing about constitutional law. He stayed with Lilly after Lawrence Tribe sank her candidacy by letting the media know that the California Supreme Court had repeatedly reversed her opinions and criticized her reasoning. Then the ABA found both nominees patently unqualified. Now, by now we were at a Tuesday, and Nixon, who had promised the public his nominations by that Thursday, needed to find two justices fast. One thing I want to do is surprise them, Nixon said of his critics, before adding the obvious. I want to screw them. Nixon had often dismissed the distinguished attorney, Lewis Powell, as too old, and he knew that Powell didn't want to become a justice. When he telephoned Powell to urge him to join the court now, he showed how criticism of his previous nominees had stung. Let's put it quite bluntly. Nobody could claim that you were a mediocrity, the president told Powell. Nixon had also dismissed Assistant Attorney General William Rehnquist as obscure, but he reconsidered when he heard that Rehnquist had clerked for Justice Jackson and excelled at Stanford, which he was assured was the Harvard of the West. In announcing his choices, Nixon, who hated elites, boasted that both Powell and Rehnquist were first in their law school classes. Now, many assumed that Nixon had always planned to choose Rehnquist and Powell and had made Friday and Lily their stalking horses. They were wrong. A day after he nominated Rehnquist and Powell, Nixon played the gender card in addressing Republican clubwomen. Although he felt lonely as the only man on the dais, he confided, that's a better break than a woman gets when she goes before the American Bar Association. While he knew that many were disappointed, he continued, we have made a beginning. There will be a woman on the Supreme Court, this pioneer promised. So the Nixon-Berger Court had come into being. Though Rehnquist and Powell were pets born of desperation, the White House packaged them as the conservative twins, and Nixon boasted that we have changed the court. But he knew that change came hard. In our elation over finally having the Nixon court, he warned, staffers forgot that we are now stuck with whatever decisions the new majority hands down. Nixon saw Justice Stewart as a captive of the Georgetown social circuit, and he fretted that media and DC parties would soften up his new justices. It is bound to happen to one or more of our new majority, he told aides, and then we will have lost the ball game. But what exactly did Nixon think the ball game was? LBJ sought to sustain the Warren Court, which he considered an ally. Nixon understood the symbolic value of the Warren Court as a target and of its potential in enabling him to create a new majority party of Republicans, white Southerners, and white ethnics. He transformed the nomination process into political theater that would pull in people traditionally uninterested in the court. The scattershot way Nixon chose nominees, though, highlighted his administration's ineptness and his own disinterest in most issues on the court's docket. As Kevin McMahon stresses, despite his anti-Warren Court rhetoric before and after 1968, Nixon was invested in the court for strategic political reasons. But if Nixon did not launch the judicial counter-revolution that he had promised, his use of the court to consolidate political power, like LBJ's before him, mattered institutionally, doctrinally, and for the nomination and confirmation process. Nixon's moves mattered for the court because the Blackmun, Powell, Douglas, Stewart, Brennan, and Rehnquist papers all show the Nixon court had little use for Warren Burger, its Nixon-named Chief Justice. Recall the portrait of Warren Burger in The Brethren as a paranoid, pompous dissembler who saw law as the basest form of politics. And this book was written with the help of 5 justices. Doctrinally, the 1967 to 71 battles may have mattered too. For example, Frank Michelman had thought that the Warren Court was ready to single out wealth as a suspect classification. A Fortis court might have subjected laws that perpetuated economic inequality to stricter scrutiny. Perhaps it would have required regional busing to achieve racial balance in the schools. Perhaps it would have given poor women a government-funded right to abortion. Perhaps it would have forced all of us to focus more on how class, like race and gender, divides us. But historians aren't supposed to dwell on counterfactuals. I feel on firmer ground in saying that these contests help redefine the way, retroactively and prospectively, the Warren Court is remembered and the way that contemporary justices are selected and confirmed. In the decades since Warren stepped down, it's become common to say that his court epitomized liberal judicial activism. Yet Barry Friedman and Corrina Lane have recently confirmed what Robert Dahl recognized long ago. Most Warren Court decisions, even those involving criminal procedure, reflected majority will. The Warren Court enjoyed far more acceptance than we typically acknowledge. In part, that's because, as Justin Driver shows, we have overlooked the constitutional conservatism of the Warren Court. In part, it's because liberalism retained considerable public support until the late 1970s, and liberals dominated the Senate. Recall the support for Marshall in '67 and the backing for Fortis as Chief Justice in '68 until the last-minute revelations about obscenity issues and his lecture fees. Add in the failure of the Republican Southern strategy in the 1970 midterm elections. I do not call for a return to the Warren Court, but I do say it may be ahistorical to say it was counter-majoritarian. In the context of the 1960s, the Warren Court's liberalism was hardly radical. Even today, moreover, Warren Court activists shine in public memory. Who besides Holmes, Ginsburg, and Scalia have been celebrated in plays and movies? Marshall, Douglas, Fortis. Even as Reagan tried to roll back the Warren Court, federal courthouses were being named for its liberal members. On the one hand, so what? That Charles Whitaker gets a federal courthouse in Kansas City means that it's pretty easy for a justice to get a courthouse. But on the other, Baltimore-Washington Airport is named after Thurgood Marshall, and schools everywhere are named after Warren and Marshall. Yet today, even liberals often run away from the Warren Court because they accept the cartoonish image promoted by its opponents with relatively little success during the 1960s. Democrats have tried to respect and reject the Warren Court by relegating it to history and by touting their nominees as non-ideological moderates. Think of Jeffrey Rosen's 1990s New Republic announcement that in nominating Justices Ginsburg and Breyer, Clinton broke free of the ideological excesses of the Warren Court and ended the age of judicial heroics. Or consider that when candidate Obama called for justices with empathy, Kenneth Starr wondered if that was code for Warren Court types. Not so, said candidate Obama, who maintained that 1960s judicial activists ignored the will of Congress and ignored democratic processes. Even as confirmation hearings feature nominees ritualistically swearing fealty to Brown versus Board of Education, they underline the bipartisan acceptance of the caricature of the Warren Court its opponents advanced in the 1960s. The 1967 to 71 contests also heralded the birth of the modern confirmation process. As I said, Reagan's nomination of Bork is credited with bringing in the modern era of partisanship. In an age of declining voter turnout, Americans mobilized for and against Bork. By implications, liberals first Borked a nominee and Bork and abortion changed the process. Since Scalia was confirmed in '86, Bork spattled the next year must signal transformation. But we should remember that the Senate was Republican-controlled in '86, while like Hainsworth and Carswell, Bork faced a democratically controlled Senate. Perhaps Bork was confirmable in '86. And while abortion does play an outsized role in today's confirmation hearings, the right to it rests on Griswold and privacy. The Bork fight underlines the continuing relevance of the Warren era to the nomination process. Bork characterized his defeat as the revenge of the Warren court. Now, the Bork fight was significant because a nominee was defeated solely because of ideology and without a cover. As Dick Howard says, though, the Bork battle did not so much change as intensify everything. The confirmation mess is rooted in the 60s, and it hasn't always been contentious. From 69 to 2000, Blackmun, Stevens, O'Connor, Scalia, Kennedy, and Ginsburg were confirmed by overwhelming margins, though Jeff Stone rightly stresses that the process has become more partisan and polarizing since 2000. Over the last half-century, the confirmation process has showcased concerns that surfaced in 67 to 71. We see despair over the kabuki confirmations in which nominees don't answer senators' questions, as they haven't been doing since the Warren era. We see media scrutiny, hearings as spectacle, as during the Fortis fight. We see the interest group mobilization that was crucial to defeating Fortis, Hainsworth, and Carswell. We see anxiety about the court's politicization, and as in the conflict of interest allegations against Justices Scalia, Kagan, and Thomas, we see nominees are more easily attacked for a cover issue than ideology. The 1960s shaped the selection process too. Consider the end of the Jewish seat, the institutionalization of the so-called black seat, and the stiffening of the expectations that nominees should possess prior judicial experience and not be presidential friends. Why did the Jewish seat vanish just as the black seat became sacred? One reason is Nixon. When Fortis resigned, Arthur Goldberg held a news conference to call the Jewish seat stigmatizing. Nixon applauded Goldberg and pledged to nominate justices because of competence, not race, religion, or region. He, of course, dissembled. He sought Southerners, and he understood the importance politically of the black seat. When Berger reported that Marshall was ill, Nixon spoke of appointing his African-American Deputy Solicitor General, Jewel LaFontaine. "You killed two birds with one stone," he said, "and the Senate bastards couldn't vote against a black woman. There's no Jewish seat," he added, "because Jews were soft on crime and hung up on civil rights." A related explanation, suggested by Goldberg's news conference for the lapsing of the Jewish seat and the survival of LBJ's black seat, lies in interest group mobilization, or really lack of Jewish mobilization. Interest groups came to prominence in modern judicial politics when the Citizens for Decent Literature charged the Warren Court with peddling porn, and liberals dug for skeletons in Hainsworth's and Carswell's closets. But Jews did not press for perpetuation of the Jewish seat because, they said, they could not oppose quotas elsewhere and demand one at the court. Although the White House said that Clinton wanted to revive the Jewish seat when he nominated Justice Ginsburg, she insisted that Jews' move from margin to mainstream meant that the Jewish seat was no longer needed. By contrast, African Americans signaled enthusiasm for the so-called black seat. Small surprise then that Nixon and his successors cultivated African Americans for appointment. Significantly, Justice Thomas arrived with prior judicial experience. After Justice Douglas's 1975 retirement, Chief Justice Burger had written the White House to say that a nominee with substantial judicial experience would more easily win confirmation because his judicial experience would insulate him from controversy. Ford listened and nominated Judge Stevens. Soon, the assumption that judges made better justices hardened into dogma. Many decided that Warren and those who came to the court from outside the judiciary before the 70s saw law as politics. Despite Justice Frankfurter's oft-quoted reminder that the correlation between judicial experience and fitness for the court is zero, federally elected office holders disappeared and prior judicial experience became a prerequisite for every justice for the next 35 years. Individuals became kosher for nomination by becoming judges. Yet scholars have shown that former judges do not necessarily experience smoother confirmations and that they disproportionately side with their home circuits. Moreover, they're no more likely to respect precedent or set aside policy preferences than the politicians who preceded them. Perhaps presidents seeking justices with shared values should look for executive branch veterans who've impressed them, not judges. For the court may lose something when it draws so many justices from the appellate judiciary. Exhibit A is always Clinton versus Jones, in which the justices outlandishly contended that defending himself against claims of sexual harassment would not burden Clinton. Even though Congress has its own problems, it might prove useful to add a legislator to the court. But when President Trump quite unusually submitted his list of potential appointees before the election, all on it were judges, with the exception of Senator Mike Lee. Over the same period that the expectation of judicial experience blossomed, that of placing presidential intimates like Fortis on the court withered. Any friend of the president's who can be painted as a crony will be torn to pieces, one Republican told Reagan privately. His Eighth Circuit colleagues worried that the distinguished judge, Richard Arnold, would not be considered for the court because he was Clinton's friend and from Arkansas. When Bush, too, nominated Harriet Miers, Slate magazine rehashed Fortis's Chief Justice fight and concluded the practice of naming presidential pals began to wane decades ago, and the wisdom of avoiding cronyism is now settled. I find this wisdom mystifying. First, though Nixon justified his choice of Chief Justice Burger by citing the need to maintain distance from the judiciary and to avoid cronyism, what he really did was to drive cronyism underground. The Nixon tapes showed that Nixon and Burger talked about pending cases involving busing, pornography, Watergate, and crime, and that Burger played the courtier much as Fortis did for LBJ. Burger never approached Fortis in influence, but it wasn't for lack of trying. Now, I realize that's not an argument for cronyism, but surely it's preferable for someone to be an overt rather than a covert crony. And while many might think that justices should be less involved with the presidents who appoint them than Fortis was with LBJ, why should Fortis spoil the proverbial barrel of apples? Cronies are not always mediocrities or ethically challenged. Louis Brandeis and Robert Jackson were both presidential cronies, and cronies have populated the court since Washington appointed Jay. It's no wiser to stop selecting intimates than it is to eliminate everyone but judges. Certainly, it's noteworthy that in nominating Elena Kagan, Obama selected someone without judicial experience, whom he explicitly labeled, in announcing her appointment, a friend. Yet as Harvard Dean and Solicitor General, Justice Kagan occupies a special place in the pantheon. And but for the Senate, she would have arrived at the court from the great feeder of the DC Circuit. The nomination and confirmation of Justice Gorsuch suggests that Kagan's appointment did not launch a new era, but may have been the exception that proved the rule. Without a doubt, though, Justice Kagan's confirmation hearing did remind us of the long shadow the 60s still cast over the confirmation process. She had, of course, clerked for Justice Marshall, and Republicans mentioned Marshall repeatedly on day one of the hearings. Would she, too, use law to help the disadvantaged? A Republican asked on day two. You'll get Justice Kagan. You won't get Justice Marshall, and that's an important thing, she responded. That didn't answer his question, the senator complained. A Washington Post op-ed semi-facetiously entitled, Kagan may get confirmed, but Marshall can forget it, put it this way. Did Republicans think it would help their cause to criticize the first African American on the Supreme Court? A revered figure who has been celebrated with an airport, a postage, and a Broadway show? Yes, Republicans did. The ghosts of the 1960s still haunt the way Supreme Court justices are selected and confirmed. Thank you.
We have time for a few questions. We'll take a few questions.
Thank you.
So the hot rumor today is that, well, Senator Grassley says there will be another retirement this summer. And the rumor mill is that it's going to be Justice Kennedy, for reasons I'm not privy to. So do you think Trump will just pick the next name off his list, or do you think it's possible that being the odd and unpredictable?
I couldn't speculate.
You don't want to speculate?
I would predict that if it were Thomas who retired, that he might choose Robert Young off his list because of an African American, or he might also decide it's time for a South Asian. We heard about that a lot as Obama, but during the Obama years. But beyond that, your guess is as good as mine. Mm-hmm. But it was interesting, wasn't it, that Gorsuch was a circuit court judge, and he went to Harvard Law School, even though there were all of those state Supreme Court justices who hadn't gone to Harvard or Yale, not that I have anything against Harvard or Yale, on the list.
I was wondering if you could relate your story about sort of political conceptions of judges to developments within the legal academy, and in particular the emergence first of the process school and later of originalism, et cetera, conceptions, sort of developments in industry of legal thought.
Right. Well, I mean, LBJ was not interested in that debate. And I don't think Nixon was either. Reagan and Mies did show a great deal of interest in originalism, of course. But what was interesting to me, going back over the earlier confirmation hearings, was that it became a kind of trope, original intention in confirmation hearings, much earlier than I expected, and specifically in the Marshall hearing.
Yes, you mentioned that the role of cronyism and the importance of judicial experience affecting how later presidents make decisions on who they nominate.
I should say I'm hard of hearing.
So you mentioned earlier the importance, and quite eloquently, of cronyism and the desire to have nominees have prior judicial experience impacting the way presidents, since LBJ and Nixon, made decisions on nominees. So maybe think of what of the people that were that President Clinton considered nominating, and to see
Right.
what extent cronyism and the lack of judicial experience affected their prospects. So I'm thinking of Bruce Babbitt and then George Mitchell.
Right.
So
Right.
George Mitchell was a judge for 8 months, I think.
Right.
But Babbitt had not been. He was an attorney general, I believe, in Arizona.
Right.
I don't recall the debate being one about cronyism or about lack of judicial experience, but
Well,
I don't know, I don't have the historical knowledge you have.
Of course, as you remember, Clinton talked about Mario Cuomo. He originally said he wanted someone with a big heart, and then he turned to Bruce Babbitt, and it looked like he was going to break with the mold until he interviewed Ginsburg and fell in love with her story. What was interesting to me in the Clinton, going through the files in the Clinton library, was the depth of Clinton's desire to appoint Richard Arnold to the court, which of course would have been a great appointment, and the extent to which people, and Arnold's biographers talked about this too, the extent to which Arnold's colleagues on the Eighth Circuit and people in the White House worried that cronyism would prevent him from becoming a justice. Now, ultimately, probably Arnold's health was more important, but I did see the sort of specter of cronyism rear its head even for Clinton. Justice.
So I wonder to what extent your story can be understood as one of overreach, but not overreach by President Johnson, but instead by Chief Justice Warren. And I'm thinking about his paying attention to the 1968 election, and he dislikes Nixon intensely as a result of their history in California. And had Warren stepped down earlier, it would have been possible for Johnson to get a successor confirmed that would have been to Warren's liking. And so rather than viewing Johnson as the person who became too aggressive, maybe it was Chief Justice Warren himself.
Well, as Jeff Stone has said, I think Warren, Fortis could have been confirmed in 1967. But again, I don't think that Warren necessarily overreached, because what was interesting to me, and this time I went through this story, having earlier in my life, 30 years ago, written a biography of Abe Fortis, was how easily it probably could have been that someone like Goldberg or Senator Philip Hart, the conscience of the Senate, could have been, or even probably Brennan, could have been confirmed even in '68. So I don't think that it was that Warren overreached. I think it was that Johnson, as you say, he coupled Fortis with the wrong candidate, Homer Thornberry, but he believed that he was making a shrewd choice because Senate conservatives would reason that they were getting rid of Warren and getting Homer Thornberry, who would be more conservative. So he thought that the Senate conservatives would see that he was moving the court in a more conservative direction, while admittedly preserving its ideological momentum. And Senate liberals would think, oh, Homer Thornberry is the best we can get to go along with Abe Fortis. But he probably just shouldn't have tried to nominate Abe Fortis at all, given Fortis's, personal problems, given the fact that he carried the double weight of identification with the Johnson administration and identification with the Warren Court.
Two questions. So one is Arthur Goldberg. So a key moment in this history is Goldberg's decision to acquiesce in Johnson's desire to put him on the UN, U.S. representative to UN. But why did Goldberg accept that? I mean, I know years later when I was working for Justice Brennan, every time the Bergen court handed out a bad decision, Goldberg would come and say to Brennan, it's all my fault. And of course, he was right. So why did he agree to give up this lifetime appointment, which I assume he enjoyed and felt powerful, for this short-term, not very important thing in the grand scheme of things?
When I interviewed him in the 80s, I must have been like the zillionth person who asked him that. He just had one word, vanity. You know, he thought he could go, LBJ, if you listen to the conversations between him and LBJ, which, I mean, I love doing it. I actually, that was what got me started on this book. I got so taken by LBJ's telephone conversations that I once played them at Thanksgiving. But if you listen to what Lyndon Johnson is telling Arthur Goldberg, he is definitely leading Arthur Goldberg to believe that he can arrange a negotiated settlement to the war in Vietnam. And that was a big deal.
Right.
And he's making Goldberg think that he'll have the access, which of course Goldberg didn't have.
The second question, I had really come to this notion about appointing judges to the Supreme Court. I mean, I have to say, if I think about this as a matter of first principles, it makes complete sense to me, right? I mean, basically, people who haven't been judges haven't had the experience, haven't demonstrated the capacity to do this well. And so it seems to me the move to appointing the Court of Appeals judges or state Supreme Court justices makes eminent sense. So why didn't they do this in the past?
Well, I think the answer is because some people without a lot of experience showed themselves to be very eminent justices, like Felix Frankfurt, for example.
Well, it's questionable whether he was an eminent judge.
Right, yeah. I mean, he's not one of my
He's an eminent
favorites.
scholar.
But yeah. Robert Jackson, you know, lots of justices in the past. And I understand what you're saying, and it makes sense to me, but do you have to have only federal appellate judges there? I mean, wouldn't it be good, you know, I mean, obviously you probably figured out I'm kind of a liberal, and, you know, Senator Mike Lee wouldn't have been my choice, but wouldn't a senator on the court be good for helping the court get over its antipathy towards, say, legislative history and understanding more about how Congress operates? I mean, do we only have to have justices from this narrow a bandwidth? I understand that people who've excelled at Harvard and Yale are probably, you know, the best at doctrinal analysis, but what about Chicago?
We haven't done too well between Bork and Ginsburg, so.
Yeah.
So it seems like one of the most striking things about the presentation is how short-term Nixon's vision of the appointment process was. I mean, it's all near-term partisan advantage. That was first and foremost in his mind with these appointments. I guess the question would be, was there any thought about long-term durable constitutional change by putting these people on the court within any discussions? Or is that just not part of it? And then when do you see in history this becoming a more prominent part about how we select our justices?
That's a great question, and I do think that LBJ was thinking about it in this way. I think he was thinking about preserving the Warren Court's ideological momentum. But with Nixon, I was shocked at the lack of concern he displayed about this issue, lack of concern he displayed with this issue, and with the lack of vetting that he did with his candidates. Powell, the FBI check doesn't begin on Powell until after Nixon's announced his appointment. So this is a really, really haphazard process during the 1970s and even during the Johnson years in terms of vetting too. I think it begins to become a more coherent process in terms of vetting during the 4 years with Ed Levy. It's Levy. Okay, thank you. Had to come to Chicago. I think that ideology becomes much more important along with vetting during the Reagan years, but even in the Reagan years, you have, you know, mishaps like Douglas Ginsburg's nomination, which was incredibly poorly vetted. So it may be that the full vetting doesn't emerge until Anthony Kennedy, who is quizzed for hours and hours about, you know, whether he's ever had sex with animals, by all accounts. So, I mean, I
That's the
think
next opinion.
I think that you, I think that you, by the end of the Reagan years, you're seeing much more concern with vetting, although then you do have Clarence Thomas. Certainly by the end of the Reagan years, you're seeing a lot more coherent concern and with ideology, and you have, I mean, if you go into the Reagan library and you look at the way the Justice Department is lining up the nominees, they're doing it much more carefully than any previous administration I've seen, and I've gone to presidential libraries from Eisenhower on. Sure. Oh, I'm sorry, you were.
I was going to ask about the other bandwidth, which is the narrowing to graduates from Harvard and Yale and the occasional Stanford. So that when you look for who might be, if the pattern continued, we could, just to illustrate how narrow this is, 10 years from now, we could expect that we could look at who was in a graduating class at an age-appropriate time from Harvard, a large law school, Yale, a smaller law school, who then clerked for the United States Supreme Court, or perhaps then went to the Solicitor General's office.
Yeah.
And that's a relatively small group of candidates onto which you can always project political choice. And it means that if you are selecting from someone from the Court of Appeals, United States Court of Appeals, you're in all likelihood selecting from a broader educational base than you are from that bandwidth. What do you think it would take to overcome the control that that particular type of narrowing has on the selection process?
That's a great question, and I'm just a little historian. I don't know that I can answer it, but I mean, even though I'm not a Trump supporter, I did find some sort of great happiness in seeing the relative breadth of his list. So maybe it will be Donald Trump who, you know, reaches down and picks someone off the wilds of the Utah Supreme Court or something that will sort of reopen things again. And I'd love to see some cronies back on.
Jared Kushner. The narrative you've given us is an individualistic one. And I want to ask you about a more institutional one that's been proposed by political scientist Nancy Scherer. And what Scherer's argument is about lower federal court judges, so I want to know if you think it applies. What she said is what happened was that the base of political parties changed from patronage to interest groups. And that because of that, cronies were no longer acceptable because elected officials had to look to interest groups for their campaigns and their futures. Cronies didn't help them, and so that politicized everything, and you're seeing that playing out with Johnson and Nixon. Does that work? And then going forward?
It wouldn't, offhand, it wouldn't seem to, I mean, and I've been really influenced by the APD literature about the court, by, you know, McMahon and stuff,
Right.
but I don't think that would really work for the court, because I think there were cronies Like, for example, Attorney General Ed Meese, who stood for specific things, who would have had lots of support if there hadn't been this warning to Reagan, don't pick a crony. Anyone who can be seen as a crony will be torn to pieces.
So you mentioned early on that the last time the Senate really gave Supreme Court nominees a hard time was in the mid-19th century. So like 1 out of 4 nominees. What period of time was this, and what was driving that period of contention?
You're mostly looking at the Grant and Tyler and Cleveland administrations for big fights that often have to do with divided government, which, as you've shown, is a very important factor in understanding the 20th century confirmations as well, even though, as you say, it doesn't explain everything. So they're more isolated, to specific problems that presidents are having with Congress, like Tyler.
You talked about the emergence of the law and order frame during this time period. I was wondering if you saw any mentions of colorblind, which is some ways the flip side of that coin, during the 65 to 71. Had that emerged yet during the confirmation hearing?
Well, yes, I think so. I mean, I think that the law and order is a way of racializing concerns about crime without doing it very explicitly. And that for some Southern senators who are trying to get on that law and order bandwagon, like Fritz Hollings, who is Hainsworth's big booster, they're realizing that the Voting Rights Act is changing the South. Within a year of the passage of the Voting Rights Act, African American voter participation in the Deep South had doubled. So Hollings knows that, as he says to one of the correspondent, as long as Strom Thurmond is the Republican from South Carolina, African Americans in the South don't have any place to go but the Democratic Party. But at the same time, by focusing on law and order, he can display principled opposition to the Warren Court without alienating his African American constituents. So it's a sort of form, what I see going on is sort of early dog whistle politics.
I'm wondering how to think about Justice Souter. Now, on one hand, he was head of the First Circuit, but only very briefly before he was nominated. And Bush one didn't know him personally, but it was his chief of staff, John Sununu, that pushed him very hard, and it was a kind of trust me sort of appointment. So is he an example of a kind of crony, the chief of staff's crony, or is he more sort of the advance of judges?
I think he is an example of, and a big mistake from the point of view of conservatives, that he relied on, trust me, he's good. This was the big, what if Kenneth Starr had been appointed instead of Souter, as almost happened? That would have been the big opportunity to turn the court to the right that Bush missed. Just as if Reagan had coupled Bork with Rehnquist, who provided a lot of protective coloration for Scalia in '86, if he had coupled Bork with Rehnquist in '86, and then gotten Scalia in '87 with the Democratic Senate, that also would have turned the Senate way to the right, the court way to the right.
Well, please join me in thanking Mr. Kalman.